There are many scholars and investigative journalists who've dug into the different ways in which the fossil fuel industry has sunk its tentacles into many aspects of policymaking, in its trade associations and industry influence. So it's not just influencing legislation and trying to roll back regulation or the power of instruments in the United States like the NEPA, the National Environmental Policy Act, that allows us to review whether actions are going to harm the environment or too risky. But they've been, clearly have a vested interest in keeping the world hooked on their products, right? We know that. And we see that manifest in lots of different ways, including, what we often refer to as the escape hatch or plan B of the fossil fuel industry, is to continue to drum up and manufacture demand for its products in the form of petrochemicals and plastics. One of the key links between the climate crisis and the plastics pollution crisis is their common roots in the fossil fuel industry. Plastics are 99%, made of fossil fuels, right? And so the oil and gas industry has been actively seeking to promote and relying on growth and demand for its petrochemical products and plastics to keep the industry afloat as demand for fuel goes down in the face of ever more competitive renewables. That tactic of both drumming up and manufacturing demand or locking in dependence on their products, and also impeding progress on leveling the playing field, frankly, by taking away the subsidies that the fossil fuel industry gets to the tune of many billions of dollars a year, as we know, to, also standing in the way of policies that we know would enable a switch. And that kind of interference, as well as the greenwashing and the climate washing of their own products, is a huge part of it. And the focus on techno fixes is probably a whole other show, but it's also one of the tactics we've seen the fossil fuel industry really engage in by saying, oh, no, we don't need to get rid of fossil fuels. We can clean up or decarbonize fossil fuels. Fossil fuels are carbon. They are hydrocarbons. We can't decarbonize fossil fuels. And the problem isn't just fossil fuel emissions. It's fossil fuels themselves, for many reasons, for health reasons and toxicity reasons, for climate reasons, for social and economic reasons as well. So the tactics are manifold, and they really do have deep experience in strategy, and their war chest has unfortunately been robustly inflated in recent years, particularly as conflict-driven volatility has inured to their benefit.
The amount of money they have to spend to basically play out these cases as long as possible, is it feels daunting at times compared to what the coffers of the activists might have. What are some other ways that these oil companies are using the law to their benefit, or reacting to the plaintiffs that have brought these cases?
Well, unfortunately, and perhaps not unsurprisingly, what we're seeing in recent years, and very much so now, is an uptick in backlash generally against climate activists and advocates, against claimants who have the courage to confront power and to demand that corporations change their conduct and to stop destructive activity. And whether that takes the form of intimidation and harassment and direct brutalization in some cases of communities on the front lines of oil and gas developments and projects, or the abuse of legal process. We're seeing a rise in what are called SLAPP suits, right? Strategic lawsuits against public participation, really designed to silence and chill attempts at accountability and legitimate forms of public expression and intervention. We know, Greenpeace is facing a massive multi-million-dollar claim for its support of indigenous-led resistance to and organizing around in opposition to the Dakota Access Pipeline. And we know in Australia, organizations that have been confronting gas development there are facing similar types of silencing suits. And what's really been striking this year is that those SLAPP actions are not just being used against the activist groups, as listeners might traditionally think of them, but we've even seen in this past year, an international oil company initiate litigation against its own shareholders to get them to withdraw and back down from bringing climate related resolutions to their shareholder meeting, right? So we're seeing this intimidation tactic being wielded against their own shareholders and those who are really exercising rights of the kind of corporate democracy that, you know, supposedly these corporations are committed to, that kind of shareholder engagement. And beyond that, we're seeing looming very large resort to another legal stick that the fossil fuel industry is among the wielders of, and I would say perhaps the biggest user of, is what's called the investor state dispute settlement system. So this is really a system of relatively opaque or secret courts. They're arbitral courts, so they're bodies of arbitrators. They're kind of a private court system that allows foreign investors to sue states, so to sue governments when those governments' decisions or policies allegedly harm the investors' returns or impair the investors' rights, as the investors say. So this is a system that really empowers foreign investors to challenge state action in a way that's really unparalleled. I mean, no other entities have this same kind of access in before arbitral bodies that are really unreviewable or unaccountable, right? They're not subject to some common appellate, review. But what this means and what we've seen is that the fossil fuel industry is the largest user of the system and has been really turning the polluter pays principle on its head. So when a government tries to take action to address an environmental or public health problem, and in this case, climate action, that the government has a duty to undertake, really, to protect the human rights of the population, to protect the environment, that investors are saying, pay us, effectively saying, you've got to pay polluters to take climate action rather than making polluters pay, right? Which is a principle that's pretty well grounded in many domestic and international laws. So this is a weapon in the hands of the industry that we really need to take away and disarm them from using.
Is the argument that the state is making a judgment that is going to materially harm the company, and so you're preventing us from making the money we would normally make, so you owe us that money. Is that basically the argument?
There are many different forms that the argument takes, but that, at a large level, in a simplified way, I think that is what it boils down to in many cases. What's promising is that, we're seeing a real uptick in awareness about this incompatibility between this system. Like, we can't just let this system persist, right?